Morning, ladies and gentlemen. Let me thank, first of all, the organizers of this conference for the excellent idea of the topic of the conference on the 70th anniversary of the European Convention, and also to attracting here to this conference really excellent and extraordinary speakers from Central Europe. I think that the Central European Academy and the Mádl Ferenc Institute fulfills a mission with this, and I'm honored and thank the organizers to be present, and also thanking Mr. Deputy Minister and Professor for the introductory words. When I arrived to the court 6 years ago, the president at that time told me that here you have several tasks. First of all, to deliver judgments on human rights violation, etc. But similarly important is to disseminate the ideas of human rights, to explain to the outside world what's going on in the court. So take part in conferences like this one. It's also our mission as judges of the European Court of Human Rights. And I'm especially honored to say that in 2 weeks, I was invited for 3 conferences that are some way connected either to the convention or of the European Court of Human Rights here in Hungary. Turning to our topic, Central Europe and the margin of appreciation, I think that as already the introductory word underlined, that the European Convention on Human Rights and its protocols are agreements under public international law. Their observance and the protection of fundamental rights are primarily the tasks of the domestic legal mechanism and the national judicial system, which is very important to underline that the Convention is, first of all, applied by the national judges, national authorities, and domestic judges. This is reflected in the Convention system's so-called subsidiary character. The European Court of Human Rights exercises its jurisdiction of review only after the exhaustion of the domestic remedies. So it's a very strict requirement. The Convention presently governs, as we have heard, 46 states, and there is no doubt that the entire legal framework of the Europe-wide protection of human rights, to quote a former judge from England, John MacDonald, I quote, rests on the fragile foundations of the consent of the contracting parties. So the second keyword is, after subsidiarity, is consent. Let me mention from the Central European point of view that the enlargement of the Council of Europe after 1990 basically changed the entire system of the Council of Europe and the human rights protection system. And it was necessary to introduce a comprehensive reform of the convention system and also of the court's work. So here I am quoting from a document actually that was adopted in Budapest in 1992. As we have heard, the Deputy Minister of Hungary was the first to join the Council of Europe after the political changes. And in 1992, seeing that a lot of countries from former Soviet Union, among others, apply for membership, to set the boundaries of Europe and to set the thresholds for the countries to enter the Council of Europe. And this document was actually discussed by the Parliamentary Assembly actually in Budapest. And this underlines that the changes in East and Southeast European countries are setting new tasks for the Council of Europe. They are forcing the organization to redefine the boundaries of Europe, because this was also a question, where is the geographical boundary of the continent? And consider the cooperation with non-European states and adapt new working methods, and also to set up the standards for the rule of law, human rights, fundamental freedoms, and democracy. The most important change, in my view, the conference was in 1998, because after the huge enlargement of the Council of Europe, new methods, new implementations were necessary, and protocol number 11 that entered into force in 1998 replaced the original structure of the human rights protection. That was a commission. The commission's task was basically to filter the applications, and only a few applications could arrive to the court, but always with the consent of the state involved into the case. This protocol changed the situation, and instead of a commission and the court sitting a few days per month, a single full-time court was established, set up. This change put an end to the commission's filtering function, enabled applicants to bring their cases directly to the court, not to the commission, but directly to the court, and opened up the possibility of this direct individual petition. And maybe the most important change was that the court's judgment became compulsory to the state, was not depending on whether the state accepts or not the judgment of the court. So the fact that this mechanism is purely judicial in nature is an undeniable improvement of the former system. The right of individual petition and the compulsory jurisdiction of the court no longer depend on decisions of the state. So in this setting, let me address my main task, the activism and the restraint of the court and the judges of the court. Because the assessment of the functioning of the court is two-phased. On the one hand, the court is criticized for its activism, but on the other hand, is recognized that the court is aware of the limitations of its powers as an international court and tries to respect the decisions of domestic authorities and courts. Arguments most often put forward to demonstrate that the court is too activist include, among other, first of all, the living instrument doctrine, already called by the previous speakers. The living instrument doctrine is a judicial interpretation developed and applied by the European Court of Human Rights to interpret the European Convention on Human Rights in the light of contemporary conditions. Here, for example that the court reiterates in this connection that the Convention is a living instrument which must be interpreted in the light of present-day conditions. The present-day conditions, that's the key concept, and the ideas prevailing in democratic states today. So that's what makes the 70 years old document living always in the present time. Of course, this can be disputed, can be discussed. For example, this basically outrules the use of the original intent doctrine. It's also a general way of interpretation of human rights or fundamental rights documents. But so this activist interpretation of the convention is counterbalanced by the consensus doctrine, the European consensus on the issue, the principle of subsidiarity, and the margin of appreciation. The two latter, the principle of subsidiarity and the margin of appreciation, as you can see, now it's part of the convention since the adoption of protocol, entering into force of protocol number 15 in 2021. And here, this is the preamble, what I'm showing you is the preamble of the convention. It says that the principle of subsidiarity and margin of appreciation are now in the written text of the convention, not only judicially invented tools that actually both principles were worked out by the court to show the limits of the court vis-à-vis the member state. But not only the text of the convention rests on the consent of the contracting state, but the principles and standards rely on a similarly judge-made doctrine, the European consensus doctrine. This doctrine means that in the case of consensus among the state, less discretion is left to the state, or conversely, the less consensus there is, the wider the margin of appreciation of the member state is left to the member states. Margin of appreciation will also be referred to by academicians as appreciation, discretion, latitude. The fields of latitude allowed to the state under the margin of appreciation doctrine can be classified in two main groups. Firstly, differing local circumstances may justify it, the different approaches in the different countries, different legal cultures to the issue. The main argument here quoted by the court is that national authorities are in principle in better position than the international judge to decide. Therefore, is subsidiary the role of the court. Secondly, the second group is that the lack of European consensus enlarges the sphere of action of the state. So it became a consistently used doctrine in the jurisprudence of the Strasbourg Court that the Convention leaves a power of appreciation to the contracting states. The doctrine has a territorial and a temporal scope. Under the territorial scope, the court allows for a margin of appreciation because of the territorial relativity of, first of all, public morals. Under the temporal scope of the doctrine, the court recognizes the significance of legislative evolution within the states, similar to the changing attitudes of the state towards questions of morals. This is a first versus United Kingdom judgment that since the United Kingdom is considering to leave the Council of Europe, this was on electoral laws, actually the electoral or the voting rights of prisoners. But I'm just here quoting for that it says that there has been much discussion of the breadth of this margin in the present case, namely the voting rights of prisoners. The court reaffirms that the margin in this area is wide. There are numerous ways of organizing and running electoral systems and a wealth of differences in historical development, cultural diversity, and political thought within Europe, which is for each contracting state to mold into their own democratic vision. In order to maintain a balance between European supervision of domestic violations of human rights and respect for state sovereignty, the Strasbourg Court has developed the consensus doctrine. The autonomous interpretation of the Convention means that the Convention concepts are to be regarded as parts of a self-governing legal system that must be interpreted independently from the legal systems of the contracting states. So being familiar with the pros and cons, with the arguments in both directions of the discussion of the consensus and margin of appreciation, being aware of the related arguments, I would like to draw your attention to risks of these doctrines, of this consensus doctrine. The first risk is minimalism. As international law and international judicial organs based on the consent of the states determine the minimum level of human rights protection. This applies to the Strasbourg Court as well. Lack of European consensus and the consequent discretion of margin of appreciation doctrine opens the way for minimum level approach. However, well-established democracies have also failed on a number of occasions to comply with this minimum level standard either. The problem to be discussed here is how minimal standard Strasbourg jurisprudence influences the national courts, including the Constitutional Court. Second risk is relativism. The question that lies beyond the balancing of European standards and domestic particularities is whether the protection of human rights may vary from country to country as public morals vary. How far does the influence of cultural relativism and the shifting nature of what we call contemporary values stretch? In Danish in Rasmussen versus Denmark case, the court showed its flexibility regarding the application of this doctrine, saying that the scope of margin of appreciation will vary according to the circumstances, the subject matter, and its background. In this respect, one of the relevant factors may be the existence or non-existence of common ground between the laws of contracting states. So I agree that the conceptualization of human rights cannot be independent from cultural traditions and is determined by the given historical context. Although the standards used by courts necessarily vary when decisions are taken on the ground of differing circumstances, The excessive flexibility of those standards undermines the credibility of judicial decisions. This might be the case when, at the interplay of consensus and discretion, the common ground and margin of appreciation criteria are both flexible and both varying. I come back again to the 1998 reform that actually changed also Article 35 on the right of individual application from any person, non-government organizations or group of individuals claiming violation of the convention. In performing this role of protecting individuals, but especially as regards the application of this Article 34, three considerations will shape this approach of the court. The first is that the court is not a first instance court after the domestic court, so it does not go into the factual details. This sometimes, honestly speaking, is difficult to exercise this self-restraint because a judge, at whatever level of the judicial system is, wants to go to the facts, to clarify the situation, etc. So we say that we are not a first instance court, but very often we are acting as a first instance court, and then we try to moderate ourselves, not always successfully. The second approach, second consideration is what mentioned several times, the principle of subsidiarity, and the third one is the margin of appreciation. The court repeatedly emphasized that it's not a further court of appeal from the rulings of national courts, not a first instance court, and does not examine whether the rulings of the domestic courts were in some respect in error. An example of this approach is in a Bulgarian case that the court has said on numerous occasions that it is not called upon to deal with errors of fact or law allegedly committed by the national courts. It's not a court of first instance, not called upon to reassess the national court findings, provided that they are based on a reasonable assessment of the evidence. Or to quote a Hungarian case, Somorai versus Hungary, the court is not competent to rule formally on compliance with domestic law or other international treaties or EU law. It is therefore primarily for the national authorities to interpret and apply domestic law, etc. And so therefore the court was not acting here whether the Hungarian courts decided rightly on the to refer the case to the European Court of Justice or not. So the principle of subsidiarity gives primacy to the implementation of convention rights by national authorities, and this entails a degree of difference to their assessment as to whether the particular measures affecting right are not obsolete, are consistent with those right. The Hungarian case, the Magyar Helsinki Bizottság versus Hungary, introduces, this is an example for another interpretative method, that the rights and freedoms should be interpreted and applied in a manner which renders these rights practical and effective, not theoretical and illusory. This is also one panel that is used very often by the court underlying the practicity and effectivity of those rights. The emphasis on rights and freedoms being practical and effective is designed to ensure that their object and purpose is realized, and this may also make it is essential to be prepared to look beyond the text of individual provisions in order to establish their meanings. So this is, again, how to say, goes to the activist part, go beyond the text. And for this is my favorite example. It's a Polish case, but it's a very interesting case that tried to define what is alcoholic, who is alcoholic. So this, I think, even Mrožek would be proud of this this effort, saying that the ratio legis indicates how the term alcoholics should be understood in the light of the object and purpose of Article 5 of the Convention. It indicates that the object and purpose of this provision cannot be interpreted as only allowing the detention of alcoholics in the limited sense of persons in a clinical state of alcoholism. The court considers that under Article 5 that persons who are not medically diagnosed as alcoholics but whose conduct and behavior under the influence of alcohol pose a threat to public order or themselves can be taken into custody for the protection of public or their own interests, such as their health or personal safety. It's a great achievement. What else should be solved after that this notion was clarified in such depths? The margin doctrine sits halfway between the uniform application of the Convention and the domestic protection of human rights. So the European supervision is combined in principle with the national margin of appreciation. When the court respects the power of the states, it exercises judicial self-restraint that does not use the full extent of powers for supervision or review. Thus, the International Human Rights Court is basically inspirational for the national courts. This can be well exemplified on the impact of the European Court of Human Rights at the first phase of the Hungarian Constitutional Court, when the Convention influenced the domestic constitutional review and interpretation of the Constitution in Hungary. The court referred to the Convention even before its ratification by the country, and linked the Hungarian legal thinking to the European standard, European norms, using the international instrument in the domestic constitutional review. But, interestingly, the court decision might have also a contrary effect. When one of the most well-known cases regarding Hungary, Equényi versus Hungary, actually this was the very first case decided by the court in respect of Hungary. In the right of freedom of association of policemen and firemen that actually was banned, that any political activity was banned for them. And the Strasbourg court, so to say, show understanding for the transitional period of consolidation of democracy, while at that time the Constitutional Court's philosophy was that international standards or basic standards of human rights cannot be derogated because of the historic or the transitional period of the country. After this Requényi case that determined the social causes justifying the restriction by taking into account the particular features of Hungarian history, as did the European Court in Requényi with Hungary, was quoted in 2000. It was, of course, not the first, so to say, the first period of the Constitutional Court, but the second one. And by using this reference to Requényi, the Hungarian Constitutional Court used to lower the standards of human rights protection regarding freedom of assembly or freedom of speech, freedom of association, and actually it departed from the interpretation given by the same Constitutional Court in the first 8 or 9 years of its history. And what I repeat, that the Constitutional Court always assessed the historical circumstances, the changes in the political regime, etc., etc., but acknowledging that such circumstances might necessitate restrictions on fundamental rights, but it has never accepted any derogation for the requirements of constitutionality on the mere fact that the political regime has changed. Here, there was actually strange in the story that finally the Strasbourg court declared violation regarding freedom of assembly, although the Hungarian Constitutional Court was quoting the Rekvényi judgment, was referring to the Strasbourg standards, but after a certain period, the Strasbourg Court found violation of the convention, somehow overruling the reference to the Strasbourg case law by the Constitutional Court. But this, I took just this example, and I'm sure that in other countries, Central European countries, similar experiences can be detected, that the use of international standard that exercises the respect for national legal traditions, this should be welcomed as an instance of judicial self-restraint, but not using it to reduce the level of protection afforded by domestic courts on the ground of lower minimum standards in the European consensus or in the lack of European consensus. The second danger I just want to refer very shortly is the use of, put it harshly, the double standards for different parts of different groups of countries of the Council of Europe. Here, one can detect, for example, on the issue of secret surveillance, or on the issue of the transgender, on the changes in the transgender justifications, that there are certain cases where the basic setting is set up, certain standards are set up by the court, but end up in no violation. Then these standards, already as established case law of the court, are used in cases against other group of countries, end up in violation. The most, recent example of this, and I think the worst example of this, is a Hungarian case, the LB versus Hungary, that was published a few weeks ago, on the publication of the tax debtors' names and addresses, where the court was using the so-called parliamentary review test. The parliamentary review test was applied in the Animal Defenders versus United Kingdom case, saying that although they prohibited during the electoral campaign this Animal Defenders Association to campaign or to make any statement, so it was a very, very strict restriction on freedom of speech. But nevertheless, as there was a very thorough and long parliamentary debate on this issue, the court, with one vote, that's true, ended up in no violation. That United Kingdom didn't violate the convention because there was a very thorough parliamentary review of the issue. Then this parliamentary review argument was applied to Hungary, which is a completely different parliamentary system, and they told us that there is a violation because there was no parliamentary review. First of all, it's factually not true, because as I proved in my dissenting opinion, at the very beginning when this publication of the tax debtors was introduced, there was a very deep debate in the parliament. This was already in the first parliament in 1993. There was a debate on it, and then basically, literally, the text was taken over in later piece of law. So here, actually, 2 weeks ago, I was at a conference with 3 British professors of law. One of them, without knowing that I'm in the audience, very sharply criticized this judgment. So for them, for the English lawyers, it's very strange that a very peculiar English institution is applied to a country with a completely different tradition. maybe warning me to the time. And so I think that problem can be unfortunately detected. I mean that the use of, call it clearly double standards for different groups of states within the same Council of Europe. So, let me conclude that finding balance between the evolutive interpretation of the Convention and limitations on judicial powers of the Court, it could use margin of appreciation as important argumentative framework. It makes possible to have a balanced relationship with the sovereign member states. The use of this tool is nevertheless, of course, not accepted without criticism. Critics find uncertainty regarding the function or the scope or the consequences of the margin or the inconsistencies of the use of the doctrine. Not by accident that international courts and tribunals not only do not accept but clearly refuse to apply margin of appreciation. All the other international tribunals basically refuse to apply margin of appreciation. And the critics of the Strasbourg Court also propose that the court should rather conduct an objective analysis of the member state responsibility under particular provisions of the Convention, instead of using this margin of appreciation to allowing, let's say, the individual states to act according to their traditions, etc., in lack of European consensus. However, the European Court could and had to make broad use of this margin of appreciation doctrine, and this is due to historical reasons, due to the fact that this is the first international court when international court and judges could overrule decisions taken by the national authorities, including the domestic courts. And this historical and legal setting of the Strasbourg Court made it necessarily and I think also useful to work out these concepts of the subsidiarity, of the margin of appreciation, and of the European consensus. Thank you for your attention.